Hello, everyone. Thank you for joining the webinar. Just to let you know, I'm recording the session, so I'll provide a copy of the recording along with a copy of the slide pack afterwards. If you have any questions as we go through, in your control panel, there is a questions section, and please use that, and I'll pick up any questions at the end. So, thank you very much for joining. This webinar is about the GDPR principle of accountability. Just quickly to introduce myself, my name is Mark Gracie. I run a service called Digital Compliance Hub. I've worked in the internet industry since the mid-90s and have a career of around 20+ years looking at regulation and compliance, and data protection's been an aspect of that. I became a data protection manager in 1998 when the 1998 Act came into play. So I won't go into too much detail, but just to let you know that that's me, and I'll be taking you through this webinar today. So we're going to be looking at the accountability principle, which was a new data protection principle introduced with the General Data Protection Regulation. I'm going to start with a quote actually from Elizabeth Denham, who's the Information Commissioner. This was in a report that the ICO did earlier this year around, so I guess it was probably around May, June time, because it was a year of GDPR, and it gave lots of information and background information about how the ICO has been impacted by GDPR, an increase in complaints, increase in reports of breaches and things like that. But one of the things, and this isn't the first time that Elizabeth Denham has said something along these lines, was about the importance of the accountability principle. And as this quote says, the point that actually organizations need to understand the accountability principle and what it means, and actually shift their focus, as she says there, to the accountability principle and being able to show evidence of understanding risks from data protection issues, and really how those issues impact data subjects. There's also been another quote that I've seen from her about the fact that actually they've not actually seen this in practice. So whilst there's been quite a lot said about the accountability principle from the ICO, they basically are highlighting its importance and also highlighting that from the things that they've seen, and they do consensual audits and all sorts of different things with various different organizations. They've kind of indicated that there's evidence that the accountability principle is not being necessarily taken seriously and being put into being implemented within organizations. So I just really wanted to sort of highlight the importance of accountability. It is a new data protection principle, and is clearly one that is very important to your GDPR compliance. So just to make sure you understand where it fits into things, so we have under GDPR data protection principles. These principles set out the rules by which you can process data. So there's things like the lawfulness, the fairness and transparency. So what you do must be lawful and use the lawful basis of processing. One of those must be applicable. Fair and transparent is about understanding that it shouldn't be a shock to the data subject to find out that their data is being used in the way that it is, because they should understand fully how you're going to be using their data and things like that. So that's about things like the right to be informed and the use of privacy policies to explain everything and be transparent and open. You only process data for the specific purpose you've got the data for. If you want to do something else with the data, you've got to look at what other lawful basis allows you to do that. The data you ask for has to be relevant. So you don't ask for everything, you just ask for everything that you need for the purpose to which you need to process the data. You've got to keep it accurate and up to date. You mustn't keep it for any longer than you have a lawful basis to do so, and all processing has to be done securely. And then these are all covered in Article 5. And then right at the end of Article 5, it says, as that quote shows at the bottom, the controller shall be responsible for and be able to demonstrate compliance with paragraph 1. Well, paragraph 1 is the one that sets out the principles, and this is the accountability. So this is where the accountability principle comes into it. But it goes a bit further than that. Article 24 of the GDPR also says that you basically have to do everything you possibly can to comply with the regulation. And in that very last sentence says, and whatever you do needs to be reviewed and updated when necessary. So this is the bit that essentially says it doesn't matter that you're compliant on the 25th of May 2018, if that was your target date for being compliant. You need to be able to show and demonstrate that you are compliant today, next week, next month, next year, and you were last month, and so on. So this is the bit that I think a lot of organisations have kind of forgotten about, that there was that mass panic leading up to May last year, where lots of people did lots of work to ensure that they were compliant. There hasn't been very much activity from the regulator. I think the ICO have only really done two main things, and they were both intentions to fine rather than actual outcomes of enforcement in GDPR. They've done quite a bit under Data Protection Act 1998, but they're still getting to the GDPR stuff. So the important thing here is the accountability principle applies, because GDPR has that principle as one of the rules for your data processing activities. But Article 24 actually takes that further and says that's all about being compliant all of the time. And what the accountability principle actually means is about you taking responsibility for your data processing and proving you're compliant and keeping that compliance up, as I say. So, you know, when I often talk about the accountability principle, it's essentially saying it doesn't matter that you think you're compliant. When it comes to the crunch, you're going to have to be able to prove it. And that causes quite a lot of problems for particularly when you're dealing with very complex data protection compliance issues. Maybe you've suffered a breach and you can't determine whether you've got to report it or not, or whether you've got to deal with a subject access, which is complex because it contains information about a third party in a certain circumstance. It's a complaint or something like that. Because even if you try and talk to the regulator about, do I need to do this or do I need to do that, they will often say, well, it's actually up to you to make sure that you apply the law and you interpret the way in which way that you believe that you should interpret it, and be able to prove that you think that that's the right way of doing it. So that's not particularly helpful, but that's, I guess, to be expected from the regulator, who is really not there to set precedent by telling you what you should and shouldn't do, but to actually sort of give you some guidance around some of the basic stuff. But this accountability principle is about showing, actually, we considered this issue and this is our outcome and this is why we did it this way. And I think in a general compliance perspective, if you look at what you're doing and you document all your decisions, be that whether you reported a breach, whether it's how you dealt with a subject access, whether you decided whether you needed a data protection officer, or any other aspect of data protection, then that is your evidence. So that's you proving that you believe you're doing the right thing, and you've got to keep that up. Obviously, when it comes to the crunch, you've got to hope that the decisions you made were the right ones, but at least you'll be able to demonstrate that you've taken some responsibility and you're fully aware of what that accountability principle means. So let's move on now to really what that means in a sort of day-to-day or practical sense. So let's look at what accountability means in practice. So I've kind of split it into four particular key areas: in internal processes and procedures, the day-to-day compliance, documentary evidence, and the documentary evidence is sorry, that last one should probably be governance, actually, rather than documentation, that green square. And I'm just going to quickly run through each of those sections. I don't have slides for each of those, so I'm just going to talk for a moment, and then we'll talk about what we need to do going forward. So in terms of internal compliance, that's looking at things like having policies and having trained your employees as well to understand what it is that needs to apply from a data protection point of view. How can you prove to your customers, the regulator or whoever, that your organization is compliant if you don't have internal policies that set out the baseline of what is expected in terms of GDPR compliance within your organization, and your members of staff haven't been trained to understand the basics. They don't have to become data protection practitioners and experts, but they do need to understand the importance of what the data protection principles are about, what the lawful basis of processing means, and so on. So having policies in place, having training program in place, and that includes training people who join your business or your organization. So it's about having an induction program for new starters, as well as constantly reminding and refreshing employees is an important part of it. If your employees don't get data protection and don't understand how it impacts on their day-to-day job, then you're going to struggle to be able to prove that you are indeed compliant. There is also the general organizational responsibility, which should rest at the highest level within your organization. So in a business, that might be the board of directors. In a charity, it might be the board of trustees, and so on. If you're a sole trader, then I'm sorry, but the ultimate level is obviously yourself. Now, the key thing here is that those senior managers understand what data protection means. They understand that they have to take a responsibility for that GDPR compliance across the whole organization. So they should be asking you questions about what's happening with data protection. You should be able to go to them and say, look, we're having with this issue, we need to deal with it, otherwise this might happen. And they're supposed to be able to give you the resource or the help that you might need. So internally, you should be looking, if you haven't already, getting a suite of policies, and those policies need to be quite wide-ranging. You should have a policy around how to deal with data breaches, how to deal with subject access, how to deal with individuals' rights, data protection in general, how you deal with external parties like the government or law enforcement wanting to get access to personal data, and so on. So you need to have quite a suite of policies looking at the various aspects of data protection, and you need to make sure your employees are trained, or at least the ones who come into contact with personal data. So your marketing team, for example, if they're doing processing of personal data, which I guess they probably are in terms of mailing lists and all that kind of thing, need to understand what they need to do. But maybe the office cleaner that comes in once an evening to do the cleaning probably is less necessary to be trained. But as a general principle, make sure you train your employees, keep them up to date with any changes, but keep them reminded about the importance of data protection, and also make sure that somebody in a senior position within the organization is taking ownership in the sense of a responsibility for GDPR compliance within the organization. They won't necessarily do the day-to-day stuff, and there should be somebody within your organization that does that for you. From a day-to-day point of view, it's about knowing how to deal with individuals' rights, how to deal with data security, how to deal with data breaches, how to deal with third-party processes, and so on. So it's the day-to-day compliance activities that you have to make sure you've got those processes and policies in place that enable you to demonstrate your compliance. So that's as much about taking the right to be informed, meaning that you have a privacy policy that covers all the different data subjects, and they are fully aware of how you use and process their data. It's about understanding that everybody understands the importance of security, that your IT team have implemented, if you've got an IT team, have implemented appropriate security from a technical perspective, that you're able to demonstrate you've considered all of the potential security risks from your processing activities and have got those covered off, because the accountability principle would mean that you would have to demonstrate that you have done something adequate enough to meet the requirements of data security. So that principle of security basically says you have to implement appropriate organizational and technological security methods to address the security of your data processing. So you have to determine what you think is appropriate, and you need to look at whether that's a people related thing or the way you've got things structured within your organization, and or any technical solutions that might help fix that, be that encrypting hard disks or changing passwords on a regular basis and so on. Data breaches, as I mentioned when I was talking about policies, it's important you have an internal process for dealing with breaches. Everybody has to understand what a breach means so that they can make sure somebody deals with it within the organization, because don't forget, you only get 72 hours to decide whether you need to tell the ICO about a data breach. So you need to have a process in place with regards to dealing with that, in terms of employees understanding who they report issues to and that they are able to identify what might be an issue so that something can be dealt with it. And then somebody takes responsibility to actually run through the process and make sure that you have compliance in place with regards to the obligations relating to data breaches. Furthermore, you have to also document what you did about the breach, both in terms of how you fixed it, but also whether you reported it or not. So you have to keep a log of data breaches and ones you reported or not, depending on the circumstances. So again, that log provides the documentary evidence that yes, you did have a breach, but you didn't report it and it was for these reasons, or yes, you did and the ICO should already know about it, and so on. And that is the documentation aspect of accountability in practice, because accountability requires you to prove that you've considered these particular issues. And then accountability also comes into things like third-party data processors. So a data processor is a third party who is processing the data on your instructions. That might be somebody actually taking your data and doing something with it for you, or given there is a wide definition of processing, which means pretty much everything that you're doing with data protection, everything you're doing with personal data includes things like not just the processing, but also where you're storing it, how it's being edited, deleted, manipulated, and so on. So literally anything you're doing with personal data is called processing. So that means if you're using third-party systems like a CRM, or you're using MailChimp for your email storage and sending out your email campaigns, they are third-party processors. And Article 28 of the GDPR sets out, A, you need to make sure that those processes are compliant, and B, you have to make sure you've got a contract in place, and Article 28.3 lists the terms that need to be in those contracts. So we often talk about data processing agreements. I'm sure you've probably seen some of those, and it's Article 28.3 that has led us to have these data processing agreements. And that essentially binds, in a contractual sense, the processor to certain terms of the requirement for the controller to make sure the processor is GDPR compliant. But it goes much wider than that. And if you look at what those contractual terms include, it includes right at the end. So this is paragraph H of Article 28.3. It says you must, the processor must allow the controller to carry out audits, or at least be provided with evidence that they are indeed compliant. So I think what's happened, and what's happening a lot of at the moment, because this hasn't really been tested in any particular detail, although I have seen ICO commentary about it. Typically, due diligence of a data processor is, are you GDPR compliant? Can you just give us some ideas as to how that might be? And B, let's make sure we've got a data processing agreement in place. But how do you determine that a third-party processor is indeed compliant? And should you be actioning this clause H, which says that you should be going to your processor and saying, actually, I want to send somebody in to just make sure that you really are compliant and carry out a review of your processes, or I would like you to provide evidence that you've carried out an internal audit once a year, or something like that. And it's not particularly clear from the guidance that's available what the expectations are in this area. But as I say, I've seen some consensual audit reports from various organisations over the last year where the ICO have indicated that businesses and organisations should be doing much more with what they're doing with their third-party processors. So that's about, at a simple level, you can say to a processor, are you GDPR compliant? And they can say yes. And as long as you document you've had that, you can say, well, if you wanted to, I suggest it's probably not sufficient, but you could say, well, we asked them, they said they were, and therefore we're happy. And here's the data processing agreement in place. But there is that implication that actually should be going much further than that. And if you're a processor, it's probably a good thing for you to then have some kind of GDPR statement. And if you look at some of the big well-known names like Google and Dropbox and things like that, you'll see that they have actually quite large sections of their site that talks about their GDPR compliance, how they are signed up to Privacy Shield because they're US based, and so on. And maybe if you're a data processor, you might consider having some kind of GDPR statement along those lines to sort of fend off controllers being worried about it, or even wanting to do a lot more. So this day-to-day activity is about complying with what the law tells you have to do, but also documenting along the way, having processes in place to show that you know what to do in different circumstances, whether that's a right to erasure and how you deal with that, or the right to subject access and so on. And in terms of general documentation, there is a requirement for you to document your processing activity. If you're a 250 plus size business in terms of employees, then you must document everything. If you're smaller than that, then you have to document the things that you do on a more regular basis. So what that means for most organizations is you have to have some documentation that demonstrates you understand what data you have in your business or your organization and how you're processing it. So you should have some kind of data register that indicates that you know what kind of data it is, who that data relates to from a data subject point of view, who has access to it, what systems store it, what due diligence and other things you've taken out carried out to make sure that you're compliant, and so on. The ICO, if you look at the documentation section within GDPR on the ICO's guidance, they actually have a template you can download. It's quite complex, and they've got two color codings for the columns depending on whether they believe that it's mandatory or some of it's optional. So you might want to sort of just deal with the mandatory stuff, which is a minimal of what you should be doing. But in reality, if you were ever questioned by the ICO, you would be expected to be able to demonstrate you understood what data processing activities take place, or what your data flows are around your organization, and so you have to have that documented as well. And it can be something as simple as having it all documented in a spreadsheet, or there are systems around that you can subscribe to that enable you to document that in much more detail. There are also other tools which fit within accountability. So data protection impact assessments is a good example of that. They are essentially a risk assessment. This is what we're going to be doing with the data. These are the risks that we think might happen from that processing or doing with that data, and this is how we're going to mitigate those risks. Now, the GDPR talks about only needing to carry out a data protection impact assessment where there's high risk to the data. So there's large quantities of data subjects involved, or if you're processing, say, large quantities of special category data. But actually, the Information Commissioner's Office has said what it's had as best practice for quite some time is that you should actually do this all of the time. And if you're going to be processing data in a new way, or if you're going to be changing something with the way that the data is being processed, you're implementing a new system or something like that, then you should be carrying out a data protection impact assessment. And if you're starting from scratch, so maybe you're a startup, a data protection impact assessment is a great place to start, because A, you should be understanding what it is that you're doing with your data, but B, you can then identify what those risks are. So a data protection impact assessment is a key tool to use, and again, from some of the comments I've seen from ICO, particularly through consensual audits that they publish summaries on their website about, there's a lot of criticism that people are perhaps carrying out as many DPIAs as they probably ought to. If you're relying on legitimate interest as your lawful basis for processing, so that means you're not using consent or public task or legal obligation and so on, and you're saying, actually, I've got a legitimate reason to be processing this data and it's not harmful to the data subject, you need to be able to prove that you believe that that's the case. You can't just say, I think my lawful basis for processing is legitimate interest. There's a 3-point test. If you look at the ICO's website, they've got some detailed guidance about this, about understanding that the processing is lawful, that you have an absolute right, absolute need, to do it, and that what you're going to be doing isn't going to be harmful to the rights and freedoms of the data subjects. And that test and that process is called a legitimate interest assessment, or an LIA, as it says on the slide. So again, that's another documentary way of demonstrating that you've considered a particular issue, in this case, legitimate interest, as being an appropriate lawful basis for processing. And talking of lawful basis processing, the one everybody knows about, of course, is consent. That's asking permission, and GDPR introduced some new rules around how that consent should look, in terms of it being an informed action, that somebody takes a positive point of giving you permission or giving you consent. But the accountability principle also requires you to keep a documentary evidence that you were given consent. So again, in fact, the parts of the GDPR that talks about consent doesn't just tell you about what consent should look like going forward, but also tells you that you have to be able to demonstrate you were given consent, and that's the accountability principle at work. So that's about being able to say, yes, of course, the reason we're doing this is that this person gave us consent, and they gave us consent in this particular way, or they would have been told this information, and we are able to say that they have not, to our knowledge, asked us to withdraw their consent and change that. So you have to document your consent. In theory, or what I should say in practice, document as much as you possibly can. And I can't stress that enough. And when we were talking about GDPR before it came into play, that was one of the key things, key messages to get across. Document as much as you possibly can, because that's the bit that will demonstrate that you've taken this seriously and you've done your best, which might be the difference between a telling off and a fine, or something more serious. And then finally, in that green square, which apologies I've got in this documentation, it's kind of documentation, but it's more about general governance, as well as data protection impact assessments to carry out risk assessments of your processing and how to mitigate those risks. The GDPR also introduces another thing which we've had in the UK for some time as best practice, which is the concept of data protection by design and default. This means that you have no excuse, but you have to be able to show that you have considered data protection at the very beginning of anything that you're doing. So if you're setting up a new product, a new service, a new way of doing something, data protection should be a part of the heart of that development project. So that should be making sure that you don't just create something that ends up generating or processing personal data, and yet you've not considered the data protection ramifications of it. So data protection by design and default is a key concept introduced by the GDPR, but we've had it, it was called privacy by design in previous sort of best practice from the ICO before, but it's the same principle. Always think about data protection at the heart of what you're doing, and that there's no excuses to ignore it. There's also the possibility that you will be in a sector that has codes of practice, or the Information Commissioner introduces codes of practice. There's also certification schemes which might be applicable in certain situations. There aren't that many, if any, around at the moment of codes or certification schemes, but the GDPR encourages the regulators nationally and across Europe to introduce these codes of practice and these certification schemes. And some of them may be legal requirements, but generally a code of practice isn't bound by law, but it's best practice. And again, how do you prove that you're compliant if you're ignoring best practice within your industry, or because of the type of processing you're doing? You're not going to be able to prove it if there's a best practice approach and yet you're not really following that. So whilst they're not usually tagged with some kind of legal action for failing to comply with it, I mean, there may be things like membership rules within trade bodies that you are members of that have a set of expectations, but it's about saying, well, actually, we follow that code of practice, and whilst it's not mandated by law that we do, we actually follow it as a good practice guide. So yeah, so it's a bit of a funny situation to be, where the regulator says, well, these aren't bound by law, but we might use it as a reason to consider, you know, if we're assessing you, whether you abide by any sort of industry codes. And then finally, the GDPR introduced the concept of a data protection officer. A data protection officer is somebody who, in the eyes of GDPR, at least, is mandated by law for certain organisations to have one, depending on whether if they're a public body, they have to have a data protection officer. If you're an organisation that processes lots of, say, special category of data, or does lots of large quantities of processing of data to monitor data subjects' behaviour and things like that, then you would need to have a data protection officer, and that person if you fit within the mandated definition, has certain responsibilities and expectations, both for the DPO and also for the organisation in its relationship with the DPO in terms of what it should and shouldn't be doing. But as a general point, even if you're not mandated to have a DPO, which most organisations won't be, you should have somebody who acts in a DPO-like way. So somebody who takes responsibility. They don't have to be a full qualified, well, not even qualified, but a full data protection guru, but they do need to be somebody within your organisation. You should have somebody within your organisation who takes single responsibility for data protection and making sure that compliance happens. So they're the go-to person within the organisation that helps. And you might use an external consultant for that, or you might use one of your employees. Lots of different positions have quite large touch points with personal data, so they often get, for want of a better word, lumbered with being that responsible person. So even if you're not required to appoint a DPO by law, you should at least have somebody who's taking some responsibility for compliance in your organisation. Because it sort of goes back to that training and policy point. If you can't demonstrate that somebody somewhere is taking responsibility for data protection, how can you demonstrate your compliance? So these 4 key areas and all the sort of the subsets of things that I've just gone through there are all things that fit within that accountability principle. And on the face of it, accountability is documenting everything, but actually it's much wider than that, and there's quite a lot to be considering. And the important thing, of course, is you're compliant. You need to keep up that compliance. So it's about maintaining your compliance and ensuring that you're still compliant, as I said earlier, today, tomorrow, next month, next year, and so on. So you've got that requirement because of what the GDPR says about being able to update and refresh your compliance, ensure you're still compliant, to make sure that you are doing so, and that's all part of that accountability principle as well. So in terms of what that means in a general day-to-day aspect, it's about looking at what you're doing with your data. If you should have your documented data audits list of what you're doing, what data you have, and how you're processing it. You should review this, and I would suggest at least once a year, just to make sure that it's up to date and that you've not got data that you're not processing anymore. Because if you are, then you might want to have a look at whether you've got proper retention, proper schedules in place, and so on. But look at what you're processing, what kind of personal data you have access to, make sure it's up to date, make sure your policies are up to date. The ICO and the regulators across Europe are introducing new interpretations of the regulation, and will probably increasingly do so as they start processing GDPR related complaints. So you need to make sure your policies are up to date. For example, the ICO recently published some guidance about what a month means in terms of dealing with individuals' rights, particularly with subject access. So you could look at a month being 30 days or 31 days or whatever. It's essentially the same calendar month of so it's a calendar month, and it's the same day of the following month. So if you get a subject access on the 28th of January, you've got to deal with it by the 28th of February. If you get a subject access request on the 31st of January, there is no 31st of February, so you'll have to deal with it on the 28th of February, unless it's a leap year, in which case it's 29th, and so on. So this is something that they published recently. I think it was around June time. So your subject access policy probably needs updating to clarify that, just so that you know internally that there is that time limit is not maybe what you think it is. So you're not counting the weeks, you're necessarily counting the calendar days and finding the same day the following month. See what I mean? Review your privacy policies, make sure that you are addressing all the data subjects and what you said is still up to date and correct. Refresh your employee training. As I said before, if your employees don't understand what they're supposed to be doing from a data protection point of view, how on earth are you going to be able to prove that you are compliant? So in somehow refreshing your employee training, and you might do that once a year, you might run some kind of refresher, or you might have a training module that on an online training system that you can use. Doesn't matter how you do it, but just make sure that everybody understands the importance of data protection. Make sure you're training those people who come into your business as new, that haven't had any GDPR training from your business yet. Make sure that that's included in the induction. And if you can, if you've got internal communications processes in place, then maybe think about how you push out messaging around data protection on a regular basis as well. Review your third-party processes, any data sharing agreements, or anything like that, to make sure that they're still applicable. As I said, when we're talking about third-party processes, you might want to think about sort of testing some of them and seeing if you're still happy that they are compliant as well. Review any data protection impact assessments to make sure that new risks haven't come to light or things haven't changed that you've not really got documented. Make sure you understand where in the world your data is being processed, and this is going to be particularly important depending on what happens with Brexit in terms of a deal or no deal, but there are rules around where you can and can't share data and what needs to be done if you are going to be processing data outside the EU. Check your other documentation essentially, so make sure you're still documenting your consents, that you've got a subject access register, you've got a breach register, you've got anything else that documents some of the decision making around what you do with data protection. You might want to carry out spot checks. I realise that's a challenge for some organisations, that it's difficult to implement that, but test some of your processes and procedures and make sure that they are still working, because if something did happen and you needed a procedure to be followed and it stumbled at the first block because somebody somewhere wasn't realising they needed to worry about it, then you would be highlighting a problem. So again, by showing that you have carried out spot checks is another way of you showing that you've taken responsibility and you're meeting this accountability principle. And it may seem like an obvious thing, make sure you're still registered with the ICO, because if somebody has missed the email saying you need to renew your registration, the ICO might be calling upon you to find out why you've not renewed. I mean, I think you probably get enough of a warning, but you'll be surprised the number of businesses who think they're registered to go to the registration list of registered organisations and find that they're not listed there anymore. So check that as well. So all in all, the accountability principle kind of says you have to, it's not good enough that you think you're GDPR compliant, you've got to prove it as well. But actually, when you look at it in a lot more detail, there's actually quite a lot that needs to be done. So just a very quick sales pitch. If you need help, then that's what the Digital Compliance Hub is all about. We provide ad hoc, pay-as-you-go consultancy support. So whether that's something like dealing with a breach and you need some input as to whether it's reportable, or you've got a complex subject access request, or you're being challenged over a contract, or you're not sure whether a processor is compliant or whatever, then we can provide support services, either in terms of just pay-as-you-go when you need it, but we also run a subscription-based helpline, which is unlimited email and phone support, backed up by a library of resources as well. And also we offer lots of other solutions as well. So yeah, have a look at the Digital Compliance Hub at digitalcompliancehub.co.uk if you're thinking you might need some support, and more than happy to have a chat with you about it. So I hope that this session's been useful. There's time now for some questions. I mean, feel free, obviously, this one's about accountability, but if you've got something else you wanted to touch on, then feel free to use the time for that. Doesn't appear to be any questions right now, but if you want to ping them over, then use the questions section in your GoToWebinar control panel, and I'll pick them up. If nothing comes through in the next few minutes, then we'll call it a day and leave it at that. But let's